Good afternoon, everybody. My name is David Barnes. I'm a policy manager here at Americans for Prosperity, and we're joined by our special guest, Vikrant Reddy, who's a senior research fellow at the Charles Koch Institute. And we're here to talk about a pretty exciting opportunity after a Supreme Court decision this week on civil asset forfeiture. So, Vikrant, can you talk to us about the Timbs case and what the decision was?
Yeah, sure. It's really great to talk today, by the way. Timbs is one of the most interesting and fun, quirky cases of the Supreme Court term. Basically, it's about a man in Indianapolis, Indiana, who got busted for a series of various drug crimes. And at maximum, assuming the judge had totally thrown the book at him, he could have been punished by up to $10,000 in fines. Now, he also happened to have this Land Rover, and this Land Rover was worth $42,000. Law enforcement seized the Land Rover through civil asset forfeiture. And he made the interesting argument to the trial court that, look, I could only be punished at most $10,000, but you ended up taking $42,000 away from me. That's 4 times as extreme. The Eighth Amendment explicitly says that you can't have excessive fines. What you've essentially done here is put an excessive fine on me, and you violated the Constitution. This is an individual right. So he made this argument to the trial court. They agreed. He made it to the appellate court. They agreed. He made it to the Indiana Supreme Court. And they said, actually, the U.S. Supreme Court has never articulated this principle. We don't know that the Eighth Amendment applies, that this clause, the Eighth Amendment, applies against Indiana. So that is the case that went to the Supreme Court, and the court said unanimously, yeah, that's an individual right. That does apply against Indiana and all the other states.
And so, at a hand in the case, there are sort of 2 different dissents. There's a major opinion and then a dissent to see which of the different clauses of the Constitution, whether this is a privilege and immunity or a Eighth Amendment issue.
Right. So there's a concurrence. It was unanimous, and everybody totally agreed. There was a question about how, under the 14th Amendment of the Constitution, you incorporate these rights. So this is a little bit of constitutional law wonkery, but it's so fascinating. You know, the framers, when they put our Constitution together, they were terrified of a big, abusive federal government. And so they included all these protections, the Bill of Rights essentially, to make sure that the federal government didn't spiral out of control. They weren't necessarily concerned about state governments. It wasn't until the period right after the Civil War when people really started feeling like, well, you know, the state capitals can be abusive too. Those guys get together not just in Washington, D.C., but in Austin and in Albany and in Sacramento and in Tallahassee. They can trample on your rights too. You really need to pay attention to what they're doing in the state houses. And the Supreme Court started saying that all of these rights in the Bill of Rights, bit by bit, they call it selective incorporation, bit by bit, they were incorporated against the states also. They've incorporated just about every single part of the Bill of Rights against the states, but there are a few that are still out there. One that's out there is this, that was out there before this opinion, is this clause, the Eighth Amendment, that restricts excessive fines. Now, what you're talking about is this question of how exactly you incorporate them. There's language in the Fourth Amendment that says, well, it's a due process right, it's incorporated that way. There's other language that says this is a privilege or an immunity, it's incorporated that way. Justice Clarence Thomas feels very strongly that it has to be done the second way. And Neil Gorsuch appears to agree with him, perhaps. There wouldn't really be any substantive difference in the end, but I think Justice Thomas thinks it's very important to make a point about how you do constitutional analysis, how you do originalism. In a sense, I think he's writing for the law students who will be reading this opinion in the future. He wants them to understand the right way to do it. You may have gotten the method wrong and still gotten the wrong result. It's important to get the method right.
So for the people who aren't worried that the police are going to come and seize their property, why does this matter to them? Why should the people watching today care about this?
Well, first of all, everybody should worry about that. Civil forfeiture is really kind of an extraordinary practice. When people ask me to describe it, I say it just means that the law enforcement can take your stuff. And they say, well, it's got to be a bit more complicated than that. The truth is, it is not much more complicated than that. Law enforcement can have a suspicion that maybe you were involved in, that the material they find you with, your fancy car, whatever money's in your glove compartment, anything, may have been involved in a crime. They can take it from you, and you have to jump through a whole lot of hoops to get it back, even if you're never convicted of any kind of underlying crime. So I think it is something that everybody should be concerned about. And it's worth noting, David, that this opinion yesterday doesn't end civil asset forfeiture. People who are saying that are not quite reading the opinion the right way. What the opinion does do, though, is say that at a certain point, civil asset forfeiture is just excessive. It's out of control. In Mr. Timbs' case, it was taking $42,000 from somebody when they could have only been punished on a level of $10,000. I think you're going to start seeing a lot of challenges where people say that certain types of asset forfeiture were excessive. The court's going to have to make some decisions about that. Bit by bit, they're in a position to gut the doctrine.
So you're going to be seeing a lot more of these follow-up challenges in states all over the country. What else should policymakers do when thinking about what the problems are that this leaves unsolved?
Well, that's a great question because the court can maybe piecemeal sort of gut the practice of asset forfeiture, but I don't know that for sure. And what I do know for sure is that policymakers who want to be engaged in this area and want to respect individual rights can say, we should just go back and take a look at this practice altogether. States don't have to do civil asset forfeiture. You can just end the practice. But that's something that you have to do through your state legislature, you have to do through policy. That's not something for the judges.
Right, and there's a federal component as well through this equitable sharing program where states that have done good things on civil forfeiture are still allowed to route money through the federal government, right?
Yes, and that's a really good point, that the states will cooperate with federal authorities and sort of make an end around whatever state restrictions there might be on civil forfeiture, work with the feds and do it that way anyhow. That's something that we saw, for example, in the state of New Mexico. New Mexico passed probably the best civil forfeiture law in the whole country a couple years ago. A lot of people were very excited, but people on the ground in New Mexico say, yeah, but nevertheless, they can use the federal equitable sharing and just kind of go around the restrictions. So you really kind of have to tackle both the federal problem and the state level problem.
Great. Well, thank you so much, Vikrant, for joining us today. Again, Vikrant Reddy, Senior Research Fellow at the Charles Koch Institute. You can check out his work at cki.org or charleskochinstitute.org if you want to write out the whole thing. And please visit us at americansforprosperity.org to learn more about criminal justice reform, civil forfeiture, legal reform, all the different issues at play here. Thanks.